Hello and welcome to Rajya Sabha television. You're watching The Big Picture with me, Frank Rausen Pereira. Rajya Sabha Chairman Venkaiah Naidu on Monday rejected the notice given by the opposition parties led by the Congress for impeachment of CJI Dipak Misra, citing lack of substantial merit in it. The chairman held extensive consultations with top legal and constitutional experts, including former chief justices and judges, before taking the decision. On this edition of The Big Picture, we will analyze the rejection of the notice against the CJI. Joining me on the program today are Harish Salve, Senior Advocate of the Supreme Court, and PK Malhotra, former Secretary, Ministry of Law and Justice, Government of India. Thank you to both my guests for joining me on this edition of The Big Picture. Mr. Malhotra, I'd like to begin with you, of course, and let's first try and understand what are the allegations that have been leveled against the CJI.
You see, if you look at the order passed by the chairman of the Rajya Sabha, it is the circumstances leading to the case of Prasad Education Society on which the court has passed an order. Then there are certain allegations which relate to the functioning of the judge in fixing roster, and then there are with regard to the functioning of the court itself. I think these are the allegations on which the supporting material has been provided by the Honorable MPs who have moved the notice of motion. But while examining this notice, the the chairman was of the view that the notice doesn't contain sufficient material which enable him to constitute the committee for investigating the charges which have been leveled. And I think we have to understand the background in which this decision has been taken. If you look at the provision of the Constitution, I think the Constitution makers were wise enough to make a provision that if a judge is to be removed, because you have to maintain the independence of judiciary.
Yes.
If you have to maintain independence of judiciary, there should be a certainty of tenure of the judge. To maintain that certainty of tenure of judge, a difficult procedure has to be provided for his removal. And 124 clause 4 says a judge can be removed only if a motion is passed by half of the members of the House and 2/3 of the members of the present and voting, and in the same session by both the Houses, and only then the motion can be sent to the President. And for this, a procedure is to be prescribed, and the Parliament passed a law in 1968, that is way back 50 years back, and all the notices of motion so far have been examined under the procedure laid down in the Act of 1968. While laying down this procedure, certain safeguards have been built in. The safeguards are, first is, if you are moving a motion in the Lok Sabha, it must be signed by 100 MPs. If you are moving a motion in Rajya Sabha, it must be signed by 50 members of Parliament. This is the first check. Once it is signed by them, then it comes to the Speaker of the Lok Sabha or Chairman of the Rajya Sabha. Then the power has been given that he will examine it, he will consult the legal expert, he will look into the material placed before him, and then take a call, and he has the power to reject it.
Sure.
The third check is, if he decides to refer it to the committee, even the committee, after examining the material, if it comes to the conclusion that charges are not made out, then probably at that stage the matter rests there. It
Right.
is not necessary that it is go to the Parliament.
Sure.
So I think sufficient checks and balances have been done. So the first was, in his order he has said, well, 50 members have signed, so I'm supposed to consider it. So he has examined the material which was placed before him. He has consulted the legal experts. He has gone to the material, and I was going through the order, and he has relied on the decisions of the Supreme Court given earlier as to how the Speaker or the Chairman has to exercise his power, and he has followed that procedure while taking this decision.
Sure. Let me bring in Mr. Harish Salve into the picture. Now, Mr. Salve, what are the flaws in the allegations in the first place?
See, before that, let me start by telling you the flaws in the criticism of the chairman's order. Forget the detail, let's look at the big picture. The framers of the Constitution made a provision for removal of a judge. It was designed to confer a status of near irremovability of a judge. The framers of the Constitution also added provisions saying the conduct of a judge will not be discussed in the House, save and except where it comes to a removal of a judge. The removal of a judge is only on two grounds: incapacity or, and mark the words, proven misconduct. It left it to the wisdom of Parliament to make a law. Parliament made a law, and in its wisdom, while it reduced the threshold to 50 MPs of the Rajya Sabha, not half or two-thirds, to kickstart the process, it realized that there was the need for another layer of checks. And that layer of check is an examination of the proposal by the chairman. So, to suggest that the chairman, because I saw in some interview this afternoon, somebody saying the chairman has no business to go into the allegations, that's obviously wrong, because the law would then have said the moment 50 MPs table a motion, the office of the chairman will see it is an order, that the signatures are in place, and then it was filed on the correct form and in the correct paper, and it will admit it immediately. Let's also get into why there is this great anxiety to have this motion admitted. It's very simple in theory to say, oh, if the motion is admitted, there will be an inquiry, and if the inquiry exonerates the judge, he is out. Yes, very nice. Alice in Wonderland. The moment there is an inquiry constituted, they will immediately say that the Chief Justice should not discharge judicial function pending inquiry.
Mm-hmm.
I think in October he retires. What is the end result you've achieved? We did not like one judgment you gave. We brought an impeachment motion. You will not work hereafter. This is why the Parliament and its wisdom in 1968, when it made the law, added that one more safeguard, that the chairman must apply his mind. Let's examine the notice and why the chairman has, in my opinion, correctly declined to admit the motion. The charges can be generically put in three silos. One relates to personal allegations against him.
Right.
What I have heard about this case is that a medical college was declined registration by the MCI. The government declined, the High Court allowed, the Medical Council brought the matter to Supreme Court, and the Chief Justice allowed the appeal of the Medical Council of India. It said for 2017-18 the college cannot get recognition, for 18-19 they may try. That's what my impression is. Today we know that in India, it's a very sad truth, there are brokers who go around offering to get work done.
Right.
And many times they offer, oh, I know so and so, I can get it done. And if in the normal course your work is done, they say, see, we got it done, and then they pocket the money. I've seen this happen in my profession.
Sure.
They say, I know so and so judge, I'll get your case done. And if the case goes your way, they'll come and say, oh, I've given the money to the judge. Now, a lot of business people, unfortunately, in India fall for this kind of a nonsense. So, if somebody is saying that, oh, I can get your case done, it's nonsense. You have to see what is the end result.
Sure.
And to say, oh, well, if that is true, he'll be exonerated, is exactly, I submit, shows a wrong motive in bringing the charge.
Right.
The second silo is working of the Supreme Court. Now, working of the Supreme Court can never be the subject matter of discussion in Parliament. If his colleagues feel he is not allocating work properly, if his colleagues feel he is sending cases to a particular judge which they shouldn't be sending or should be sending, or the roster is not being run to their satisfaction, they will set their house in order. Can the Supreme Court tomorrow tell Parliament how Parliament should be run? These are co-equal institutions. So the chairman has rightly said, all this is beyond my ken. The third is they have dug up some old file saying in 2005 he was given some land and he did not return it. There were some collector's proceedings. They are overlooking, all this was known when he was appointed a High Court judge, when he was appointed a Chief Justice of Madhya Pradesh High Court, I think he was Madhya Pradesh, yes. Then he was appointed Chief Justice of Delhi High Court, he was elevated. And incidentally, all this happened. First happened when Narasimha Rao ji was the Prime Minister, the second, third and fourth developments were when the UPA was in power. You know, none of these allegations are of that gravity.
Okay.
The chairman would have
Point-
sat back and thought that, well, this calls for an inquiry.
Point taken. Let me take
I
the
think
point that you're
it's
making to
the
the other
great
guests
respect
as
the
well. You know,
chairman
these
has the right.
allegations are not grave enough is what you're suggesting. Let me now go across to Mr. Malhotra. You know, Mr. Malhotra, let's talk about why the chairman has rejected this particular notice and on what grounds.
No, as I said, he has examined the material which was placed before him. While going through the order I have seen, he has gone through the material and he has come to a definite conclusion that the kind of material which has been placed before him doesn't bring out the gravity of the misbehavior which is called for taking notice of motion for removal of a judge as per the norms laid down in Article 124(4). Because the kind of charges which have been leveled, they are not that grave enough which will satisfy that you remove a judge from discharging his duty. See, the gravity of the charge has to be on a higher footing. Now, if you are talking of a misbehavior, proved misbehavior will come later on. First, you have to talk of the misbehavior. If you're talking of a misbehavior, now misbehavior can be, suppose a judge is driving his car on the road and there is an altercation take place on the road with some other driver. What happens? You will say that the judge has misbehaved. Will such a misbehavior call for removal of a judge? So there has to be a level, a standard of their misbehavior which has taken place for invoking provision under 124(4).
Sure.
So probably the chairman has examined the material placed before him and came to the conclusion that there is no definite evidence which has come in the charges which have been made against the Chief Justice calling for constitution of a committee under the Judges Inquiry Act.
Sure. And as far as the process itself is concerned, what the opposition has said about, you know, the notice that has been brought to the that was brought to the chairman, they have said that they Article 217 and Article 124(4) of the Constitution is what they have said that the Chief Justice Dipak Misra should be removed from office under these articles. What do these articles specifically imply?
Article 124(4), Clause 4, provides for a judge being removed on a vote of the two houses of Parliament. And the vote is on a motion for presenting an address to the President for the removal of the judge. And the grounds for removal have to be misbehavior or incapacity. In the case of impeachment, the grounds are entirely different, the procedure is different, the voting requirements are different, and the results are different. In case of a judge, it is only presenting a motion, presenting an address to the President for the removal of the judge. And the grounds, as I said, have to be misbehavior and incapacity. Now, before the other process can start, the very first thing is for the chairman of Rajya Sabha or the speaker of Lok Sabha, as the case may be, to admit or reject the notice of the motion. Now, the chairman of Rajya Sabha was satisfied. It seems, I have not seen the order, but it seems he was obviously satisfied that there was no prima facie case made out of misbehavior or incapacity, that the charges were not substantiated.
Let's go across to Mr. Harish Salve. You know, Mr. Salve, as far as allegations, you know, regarding a senior judge or a judge of the higher judiciary is concerned, what is the due process that needs to be followed when there are allegations made against a senior judge?
See, there has been a problem always about allegations being made against a judge, and some of us, and I'm a big votary of a debate now on whether we should have a Judicial Accountability Commission. As the Constitution stands today, it doesn't make for any mechanism other than the removal of a judge. We loosely call it impeachment, but we all understand it is the removal of a judge. Yes, it is different from an impeachment. So the reason why it is different is it has to be on proven misconduct or incapacity. So we don't have any system expressly set out in the Constitution by which allegations can be considered. There have been issues where allegations of corruption have come up against certain members of the judiciary. They have now evolved, the Supreme Court has now evolved a in-house procedure, and I had the privilege to appear in one case where, if you remember a long time back, there was a Chief Justice in the Bombay High Court, Justice A.M. Bhattacharjee. There were serious allegations made by the bar against him, corruption, and some contempt proceedings were started. So in that case, the Supreme Court considered the matter, and they said, well, if you have a complaint, you bring it to the in-house committee, and we will have an in-house investigation, and on that basis, we will act. There have been 2 instances where the in-house committee has indicted people and where virtually the court or the judges have recommended action. And in both cases, action was recommended, but then finally the incumbents resigned. 3 cases, in fact. There was one Justice Sen from Calcutta, there was one judge from Delhi, there was a judge from former Chief Justice of Tamil Nadu, Madras High Court. So there have been instances where the in-house procedure has worked. That's an arrangement made by the court. Now, yes, it may not be satisfactory. What we are seeing today, we have to be careful. When we talk of gravity of offences, the allegation relating to the medical college is that of allegations of corruption. Now, it's very easy to allege corruption against a judge. We have to recognize that any litigant who's dissatisfied can say, okay, I'll fix the judge, and say, he asked me for a bribe, I didn't pay. So this is the kind of thing we have to guard against. And that is why the chairman must apply his mind. So if he has seen the papers relating to that Prasad Medical College and felt that these allegations are not worth the paper they are written on, surely that's what the check and balance is meant for, and for him to close the case.
Sure.
So yes, there could have been complaints to the in-house procedure. In the in-house procedure, if the complaints are made, somebody would have examined it, somebody would have looked at it. But some of our colleagues are very fond of first filing a PIL and then trying to take charge of the matter and run the whole thing in public domain. With the result, you wreck the reputation of the judge, even if your allegations are frivolous.
Right. Yes, Mr. Kashyap.
You see, apart from the gravity of the charges or absence of gravity, the important point to see is that in the notice that honorable members of Rajya Sabha have given, they have used terms like, out of the 5 charges that have made, they have used terms like maybe, likely, it appears, which means that they are themselves not convinced of the foundations of their charges. They themselves seem to say that it is only a probability that the Chief Justice of India may have been involved in something. So first, they have to establish prima facie case in favor of those charges, which they have obviously not done. And I suspect that the chairman of Rajya Sabha looked at these words like appears, likely, maybe. Now, they have to be proven charges.
Sure. They have to be proven charges at the end of the day, of course, rightly said there. Mr. Malhotra, what are the options now as far as the opposition is concerned? Is it only legal recourse?
Well, the order has been passed by the chairman exercising his powers, and legal remedy, if anybody is aggrieved by this order, maybe, they will be filing a petition before the Supreme Court, and Supreme Court in the normal courts as per the roster, before whatever judges will come, they will be hearing it and deciding it. That seems to be the only option. There is no other option.
So that is the only option then?
Yeah, that's the only option. There is no other option.
Okay, all right. And
They have another option,
Yes.
to sit at home and forget about the unseemly conduct in which they have been indulgent.
Yes.
Sure. Okay, all right. A quick closing comment now from Mr. Salve, and then I close the show.
I'm not very sure there is a legal remedy available. It will raise very interesting questions. Ultimately, the process is the process of Parliament. If the Speaker declines to admit a motion to be debated in the House, and the law entitles the Speaker to decline to admit a motion to be debated in the House, I don't know whether any court has the power to intervene. I have my serious doubts. If it is this today, suppose tomorrow the Speaker rejects a motion of privilege, can you move a court? Clearly not. Because ultimately, can the Supreme Court issue a mandamus saying, Mr. Speaker, first appoint a commission of inquiry, and if the report goes negative, Mr. Speaker, please call for a discussion in the House. Can't do
Right.
it.
Oh, yes, Mr.
There is
Malhotra.
a
Yeah.
I think this is a
One at a time, please.
the
One at a
remedy-
time. Yes, first starting
the-
with you, Mr. Malhotra.
This is the first case of its kind, because earlier no such situation has arisen. First time a motion has been rejected by the chairman in exercise the powers conferred to him under the law made by the parliament. So if we talk about the power of judicial review available to the Supreme Court through various judgments, the way Supreme Court has been interpreting, I think there is a possibility that Supreme Court may take a view that we in excess of a power of judicial review, probably this is also subject to judicial review. But the point which Mr. Salve is making out is also has got a validity. Well, I mean, it's because the Supreme Court itself has said that it is a constitutional power.
Sure, right.
It is a constitutional
Yes,
power.
Mr. Kashyap.
I think the remedy before the Supreme Court is to hold up these people for contempt of court,
Okay.
because they went public before the chairman had any opportunity to decide on the matter. Now, so long as
That's a serious lapse.
they had only signed the notice, they were within their rights as members of parliament.
Okay.
But before the chairman took a decision to admit or to reject it, if they went public and had a press conference, then they were indulging in outright defamation and
Okay.
contempt of the court.
Right. All right. Then on that note, we'll have to call it a wrap on this edition of The Big Picture. I'd like to thank all my guests, Harish, Salve, PK Malhotra, Subhash, Kashyap, for joining me on the program and putting things into perspective for us. That's it from me. See you again next time.